Hello, everyone, and welcome again to Criminal Investigation, emphasizing homicide investigation. Now, last class, we looked at reactive investigations, right? So remember, the ultimate goal in investigations is actually to reduce crime. It's not necessarily to solve it. It's the ultimate goal is to reduce it, which is a big takeaway, right? Obviously, the more we solve, theoretically, the more we're going to reduce. So that's what gives us the motivation is to solve them, but the ultimate goal is to reduce crime. So again, we discussed reactive investigations in which easiest example is a homicide. Police respond to a call of a dead body, and then they begin to investigate. Now, there are such things as proactive investigations, right? So these are investigations that take place before a crime is committed or before a crime occurs. So there are several types of proactive investigations. Most of them occur in a covert style condition, all right? So, for example, we have sting operations. Decoy operations, same way, undercover operations. This could be somebody posing as a drug dealer. Everybody who comes up to buys, and then they get arrested. This could be prostitution, right? Where you have somebody out there that was actually a police officer who is walking the streets, or vice versa, right? You could have a police officer who's acting as a John and making arrests that way. So again, they're acting before the actual crime itself occurs. Now, there are questions of inducement and entrapment, which we'll speak to in a second. Now, we also have things like stakeouts and surveillance, right? So if police are staking you out, it means they don't have anything on you yet, but they're pretty sure they're going to. So stakeouts do happen. They are very boring. You literally just sit there. You don't usually have like a giant camera or binoculars or anything like that. And a lot of times with stakeouts, you don't like sit right, like they do on TV, they sit right in front of the person's apartment. And you're like, oh, or house, and you're just like that. Okay, no. A lot of times it's driving around, parking a few, car lengths back, whatever it is, just to kind of follow you around and see what you do. And stakeouts are really a part of surveillance. Again, figuring out what you're going to do. Now, that being said, police do sometimes give obvious stakeouts. So one example I had was a case I use a lot. It's a client who was in a horrible accident, and his entire rib cage was metal mesh. They had to replace his entire rib cage, right? And so needless to say, he was in a lot of pain, and he was prescribed opioids, a lot of opioids. Police heard word that he was selling his opioids. Now, was he really? Turns out, yeah. I had to defend him, but yeah, he was. And he didn't go to any great lengths to try and hide it. So like, he had a really genius plan of how the cars would work and things like that, because he couldn't drive. So how it would look, people taking him to the grocery store and whatnot, and on the way him selling them drugs. So it was really smart. But the problem is police got wind of it, right? And so at first they put an unmarked patrol car or an unmarked car outside of his house. And it took him about 20 minutes to figure out who they were, what they were doing. So he came out every day, and every day they were there, and he waved to the police while he was selling drugs. And eventually the police were like, dude, we're trying to help you out here. So eventually they put a marked patrol car, right? So one with a clear light bar, officer in uniform, etc., right directly in front of his house. And he still came out every morning, waved, and kept dealing his drugs. So yeah, sometimes police can use these tools as preventative measures. And again, that's kind of the ultimate goal, is to reduce crime, whether it's reactive or proactive. Now, that being said, when we're talking about like sting operations, undercover operations, decoy operations, we have to be careful not to run the risk of entrapment. So entrapment is a legal term. And basically what it means is law enforcement induced you to commit a crime that you were not otherwise predisposed to commit, right? So let's say you're trying to do a prostitution sting, right? And you're trying to get the Johns. So you have a hotel room that's wired, and right next to it's a group of waiting officers, and every time a John comes to the hotel room, close the door, you arrest them, etc. Right? Usually we're not too worried about entrapment there. Where entrapment comes into play is when, especially we have somebody who is acting as a prostitute on the street, right? Because some guy could pull over, and I say guy because it's usually male, but they could be female. Some guy could pull over legitimately asking for directions, or just saying, hey, do you know how to get to blah, blah, blah. Now, in that case, that's perfectly innocent conduct, right? And if the person he asked was actually somebody who was undercover as part of a sting operation, and we'll just say she says, don't worry about the directions, honey. How would you like to do this, right? And name some explicit act. Then we're getting real close to entrapment if that person acts, right? Because he did innocent conduct, just wanted directions, never engaged her first about sex or sexual encounter. In fact, he just asked for directions. She engaged him in the sexual encounter. She's law enforcement, and that could equal entrapment. And there's a lot of other factors obviously come into play, how well he knew the area, if he knew it was a zone usually for prostitutes to hang out. And I mean, there's a lot of factors that come into play. But it just kind of gives you that general idea of the of what entrapment could be like, right? So again, it's something that you're not predisposed to commit, but law enforcement basically talks you into it or makes you commit the crime. So when we're thinking about information, and we're thinking about what we can get from crime scenes and get from crimes, right? It's really helpful to think of information theory, right? Information theory is what we call the battle. Now, it's also been described as game theory, right? Or puzzle theory, right? So information theory basically provides that the perpetrator, so the person who committed the crime, and the police, the people investigating the crime, are on opposing sides of a battle over information, right? So the perpetrator's goal is to minimize information, right? And if the perpetrator minimizes enough information, they win. They don't get caught. The police, their job, their goal is to maximize the information. And thus they win by catching the perpetrator, right? So this is why perpetrators wear gloves, is they're trying to reduce the information left at the scene, right? They're trying to get rid of fingerprints. This is why police look for fingerprints, is to see if there's information at the scene they can't see, but is still there. Now, police have a few, this is true of perpetrators as well. Police try to win by using a variety of tools. And again, this is true for perpetrators for the most part as well. One tool that police have that we don't really like to talk about, and this is true for perpetrators as well, but one that's kind of a tool but not really within anybody's purview is luck, right? So for instance, Timothy McVeigh, if you don't know who Timothy McVeigh is, he's the Oklahoma City bomber. So he's the one who drove a Ryder truck basically down into the front of the federal building in Oklahoma State, Oklahoma, and blew it up. Half the building just is gone. If you look at pictures of it, it was gone. A lot of people died. A lot of kids died because it turns out where his truck was right underneath the daycare. Right, so he had a lot of mental problems, including being kind of like in a militia and just like stuff that's way too far. right? So when he blew up the federal building, police had no idea who this guy was, like who they were looking for, right? There were so few clues left because there was so much explosive in the truck that nothing was left. So ultimately, after a series of mistakes that are made by Mcveigh, we get a police sketch and things like that. And we look into hotel rooms and rental trucks, and he uses his real name at one point, which is always a big no-no if you're committing crimes. But eventually police learn that looking for Timothy Mcveigh. Problem is they don't know where he is, right? So we kind of have like this nationwide manhunt looking for Timothy Mcveigh. And he was, for the most part, would probably have eluded law enforcement, most likely, except he was driving, and it turns out he had expired plates on his car. So a police officer pulls him over. They go through the whole rigmarole, arrest him, etc., whatever, because when they discover who he is, right, it's just, they caught him because they were lucky, right, because his plates expired, right? So he didn't do a good enough job minimizing information. The police trying to maximize information, but really kind of had to rely on luck. Now, what the police do have more control over is logic, analysis, and inference, right? So police are trained to take the information that they received at the scene, the evidence that we're going to look at today, and process it logically, right? How did it get here? Not weird fantasies, not weird like hypothetical situations, but realistically, logically, how did whatever this is, if what they're talking about, how did it get here? What does it mean? What does it point to, etc.? They can do analysis, right? So while the perpetrators try to minimize information kind of as he goes, police departments and law enforcement, they get the information as a whole, and then they can do an analysis and say, now that we have a lot of this information, maximized information, now that we have it in front of us, we can look through it, see what's good evidence, what's bad evidence, and see what helps us solve the case and what doesn't. And police can also make inferences, right? So the idea is they have enough information where they can infer something happened, right? So it's like somebody burns down a house and there is a person in it, right? And police go to the remains and they find on the remains cuts on the ribs, right? Well, that's inferential, saying, if there's cuts on the ribs, this person was likely stabbed. So then the fire was probably likely to cover it up. All right, that's an inference. You have a little bit of information, and from that you make some sort of conclusion, or you make some sort of next step in the thought process. Now, that being said, we have to avoid mental mistakes of confirmation bias. So if we walk into a scene or we walk into a situation thinking that this is what happened, A, B, C, D is what happened, guess what? We're going to find evidence, and only evidence, of A, B, C, and D, right? And it's because what we do is we look, and we do this all the time, right? When we look for signs from people who've passed away and things like that, we're looking for something to confirm. And again, a lot of it happens subconsciously, to confirm what we already believe, right? So we avoid this idea of making our brain, right, fight what it already believes. It's a hard thing to do. This also includes selective information processing, right? So this leads from confirmation bias, but we're looking at certain information, but we won't look at other information. So one of my favorite things to do is listen to My Favorite Murder, the podcast. Right, it's an amazing, amazing podcast. I love the ladies. I want to be their friend desperately. And if you haven't listened to it, there's like 300 episodes. Listen, take some time and listen to it. They do spend the first like 30, 40 minutes of the podcast talking about their trauma and life experiences and just kind of what's going on. So you can kind of like skip that if you don't want to hear that. But they do, what they do is they take each week a murder, and they break it down. They dissect what happened, how police did what they did, and they really break it down in great detail. And the last one that I listened to, because I'm a little bit behind, dealt with a murder, basically, of a guy's wife by a member of the LAPD, right? She made it look like there was a break-in and she wanted him for herself. I mean, it was like one of those, like, if like Hallmark movies were actually entertaining type thing. So when police get the information, they really kind of discard and discredit anything that has to do with the perpetrator being a member of law enforcement, which happens quite a bit. Not necessarily the perpetrator being a member of law enforcement, but when it happens, we take the information and we kind of separate it. We're like, okay, this information is what we're going to follow because it can't possibly be a law enforcement officer, right? We've already ruled that out. Well, then we're just looking at selective information. We're not looking at information as a whole. We also want to avoid overconfidence bias, right? So if we think we have a slam dunk case, we have a confession, we have DNA, we have fingerprints, we have everything. We don't want to stop the investigation, right? Because the investigation is designed to, yes, identify the person who did it, but also make sure that we're looking at the right person. Like, all the clues could point in one direction, but there could be other people out there. And we don't want to just rule something out and just make a final determination based upon the information that we have. We want to keep ourselves open to new information, to new potential perpetrators. Now, they also, and what we try to avoid is human inaccuracies. All right, so a lot of things that happen when it comes to criminalistics do involve technology and computers that do have error rates, right? They even make mistakes, but not at the same rate necessarily people do, right? But keep in mind, people are the ones who program these things, so they're obviously going to reflect some flaws. We try to avoid, we want hard numbers, hard data, hard facts, as opposed to just guessing. And we say this in the terms of I could say, hey, my car looks about 10 feet down the road. And in reality, like, to me, it looks like 10 feet. Maybe I just don't know what 10 feet looks like. And it's actually like 20 or 25 feet down the road. If we have law enforcement writing the car was 10 feet down the road, when it was 25 feet down the road, that could be information that is really, really helpful to have the real information, not just kind of the guesstimate. Right, so that's why we always measure. We do everything that we can to get as much data with as little human inaccuracy as possible. That being said, there are times when humans are purposely inaccurate. So if you want to look into a really interesting case, look into the forensics crime lab of the Massachusetts State Police, in which one of the analysts was just saying everything was drugs, even if it wasn't, planting the drugs, and just giving like inaccurate weights to make everything like a really serious felony. They finally caught her, and like they had to let 2,000 people out of prison before they could have a new trial. And now she's in prison. But sometimes human inaccuracies are intentional, and again, sometimes they're not. So, for instance, one thing we talked a little bit about before is the FBI's fingerprint database, right, CODIS. On TV, it looks like they just put a fingerprint into the system, and then it goes through all these prints on the screen, and then it comes up with a match. It's not really how it works, right? And we'll talk about how it works, but generally speaking, you get a fingerprint, you, as a human, identify certain unique features, right? And then you kind of place a marker on those features. Then you put it into the computer, and the computer searches for fingerprints that look like that have those markers. And then the computer will take maybe a couple days but we'll spit out information and it'll say, here are, the top 5 fingerprints that look the same, the top 5 people that look like they have similar fingerprints. And then it's on the text job to look at the fingerprint that they know is from the scene and look at each of the ones that got spit out by the computer and try to get a match, right? And again, there's a problem with that terminology. Try to get a match. Their job is to see if a match exists, not to assume that one does and go from there, because then they have confirmation bias, right? If I'm going to say, well, I know one of these people committed the crime, I'm going to be looking for everything that confirms my suspicions, but doesn't dispel them, right? So again, even how we kind of word what a text job is to do, text job is not to find a match. A text job is not to find drugs. A text job is to discover if there is a match, to discover if this does contain drugs, right? It's how we use our terminology is very important. And again, as I said before, it's also described as a game. So kind of capitalizing on the mistakes of each other. So the perpetrator will capitalize on a mistake made by police, and police will capitalize on a mistake made by a perpetrator. And we see this kind of in the DC sniper case, which if we have time, we'll kind of come back to. Now, others have described it as a puzzle, right? So we know there's certain pieces we have kind of built in, and there's a lot of pieces out there, and we have to put them together in a way that makes sense in a picture that comes out to look like the box. There's missing information, right? The problem is with puzzles, I don't like the comparison, is a puzzle, you know how many pieces of information are out there, right? You know there's 500 pieces in this puzzle. With a crime, you have no idea how much information is out there, or even how much information you'll need to secure a conviction. Because again, we'll talk a little bit more forensically about juries and things like that. But yeah, calling it a puzzle says you know how many pieces are out there, when in reality, no clue. So we'll come back to this. What I want to move into today is the role of evidence, and really kind of talking about evidence in a forensic sense. So when I mean forensic, I mean in kind of a courtroom sense, but just kind of evidence in general, a very high level overview of evidence. We're not talking specifically about how to collect it, but we're talking about its importance and its role in this whole process. Okay. So this is the basics of criminal evidence. Criminal evidence is any crime-related information on which an investigator can base a decision or make a determination. Right? So any crime-related information. So again, we're looking for that information, which the investigator can base a decision and make a determination. So is it helping that investigator one way or another? Now, the goal of evidence collection, right, and goal of evidence kind of in general, the reason we look for evidence has 2 parts, right? The first part of collecting evidence is to determine if a crime was committed. Right? So things look suspicious all the time, and they're not. So we look at the evidence to say, is there something else here? So again, using my example of the house burning down, we finding stab wounds on the remains. Well, a house can burn down. It happens. Electrical fires do happen. And usually the smoke will suffocate you before you'll get burned or anything like that. It's not a pleasant way to die, but it's at least not burning alive. Part of our job is to determine when a house burns down, was there a crime here? Right? So we look for evidence. And what we're going to find out during the course of this course, and something that you may consider doing for your final project, is looking at arson investigations. We used to have very strict rules, and we thought we knew a lot about arson. And then it turns out that most of our arson investigation techniques are not effective, or they're not true. So we misinterpret burn marks. We misinterpret a lot of things to see like how the path of the fire went. There's a lot of factors that come into play that we know today, but we didn't know 10 years ago, right? So arson investigations, they've really kind of become very problematic. But theoretically, let's say they're doing well. The goal is to determine if a crime was committed. So we're going to look for evidence, not to find evidence of a crime or to find evidence that this was an accident. We are just looking to see what's out there, right? If a crime was committed, we're not trying to prove it. We try to prove it, then we have confirmation bias and selection bias. Right? We're just trying to see if a crime was committed. Now, assuming that we find that a crime was committed, right? The next part that kind of comes into play is who committed the crime. Right? So not we're trying to prove this person committed the crime or this person committed the crime, but who committed the crime. We know a crime was committed, but now we have to find out who. Now, we often have very basic information to determine if there's a perpetrator of a crime. I mean, a lot of times we catch people red-handed, right? Or people turn themselves in, or people confess. Our job is still to look at that, not trying to prove that that person did it, but to determine if that person did it. Right? So remember, this is kind of an overused phrase, but we suit theories to facts and not facts to theories. Right? So when we get evidence, we start to think about it, process it, analyze it, use those tools that are available to us to come up with some kind of grand theory of what happened. Now, this theory has to be flexible and subject to change. Because if I think A, B, and C happened, but then I find a piece of evidence that really strongly suggests that it wasn't A, B, and C, it was A, B, and X, then my theory has to evolve and change and be flexible enough that it can now kind of pivot to A, B, and X. Maybe you get more information later. It says A, B, and C. We have to pivot back, right? So we take our theories, we base them upon the facts. We don't take facts and change them or interpret them to match our theory, right? So we don't take facts, we don't take evidence and say, well, this matches what I'm thinking happened, and I'm going to give it a lot more importance, a lot more weight than this other thing that suggests what I was looking at is actually incorrect, or my theory was incorrect. So again, we are looking always for information to see if a crime was committed and determine if there was, who the perpetrator of the crime is. So let's talk a little bit about admissibility of evidence, right? So this is stuff that we'll get into when we look at like actually collecting evidence and interpreting it, right? But this is something that you need to know before you can really see what evidence is and what information is the best, right? So when we talk about the admissibility of evidence, there are two forensic. Now, forensic is a key word here because forensic means basically court, right? We think of like forensic investigations. Well, they're done for court. So there are two forensic classifications, evidence-based classifications, or excuse me, court-based classifications of evidence, right? The first is judicial evidence, which is admissible in court, and it meets all of the rules of evidence. And then there's extrajudicial evidence, which we'll talk about in a second. So judicial evidence says this is information that you collected, this is information that you have. We're going to let the jury hear it. Now, to comply, to get to a point where you can have a jury hear it, you have to show that you've met and are not barred by the rules of evidence. So every court proceeding, whether it's at the state level, whether it's at the federal level, every criminal court proceeding has rules of evidence, right? So this link is actually to the federal rules of evidence. So what evidence is admissible in federal court? Now, most states kind of follow a similar pattern, following the federal rules of evidence, but they do have differences. But what we basically do is we have to prove that the evidence, there are hundreds of rules of evidence if you look through it. But basically, we have to show that the evidence is reliable, is relevant, and that's kind of the big two. And assuming we can do that and it's not barred by something, right? We've all heard of hearsay, which is just an out-of-court statement made inside a court to prove the truth of the matter asserted. So what that usually means is, if we're talking judicial evidence, we might have somebody who said, oh, yeah, my friend Bill said that he saw Carl at the grocery store. Now that might be evidence of something, right? We're looking at a crime, might be evidence. Is it admissible in court? No, because it doesn't meet the rules of evidence. It's hearsay, right? We don't want somebody telling us what some other person said in court. We want that person who said it to come say it in court. So it doesn't necessarily meet our forensic evidence standards for judicial evidence. However, there is extrajudicial evidence, right? So this is evidence which is not admissible in court for most proceedings, but may guide investigators, right? So that hearsay might guide the investigation of, oh, you saw Carl, somebody said they saw Carl at the supermarket. That will guide it, depending on whoever Carl is and whatever the facts of the case are, that might guide law enforcement. So while it's not admissible in court, it's still evidence, right? And that being said, if we find evidence that is not admissible in court, right? Let's say the police find evidence that's not admissible in court, and they use it, they rely upon it, or they even just discover it. And they have somebody that they've charged with a crime, and like, this is new, this is part of the investigation, whatever. They've charged somebody with a crime. It's considered Brady material. So there's a famous case after Ronald Reagan got shot. His press aide, Brady, was gravely wounded, and they passed the Brady Act. The federal government passed the Brady Act, and there's all kinds of other factors that go into it. But basically, Brady says if you're conducting an investigation, and there's somebody that's been charged, and you maybe just have something written down in your notebook from like 2 years ago, that even faintly, even just the tiniest bit suggests that that person, that the defendant, is not guilty, you have to turn over to the defense. It's exculpatory evidence. So the defense often can use extrajudicial evidence, depending on the situation, and then really on basics of fairness, to show the court that they didn't do it. Right? So maybe extrajudicial evidence is not admissible by the prosecution. It may be admissible or it may not be admissible by the defense. It can be good for the prosecution, right? But the prosecution has to figure out ways to prove what they already know, or to at least show that it exists. Or it can be bad for the prosecution. If it's bad for the prosecution, even if it's not admissible, you have to turn that information over to the defense. Now, the defense, they're going to conduct their own investigation. They generally do not have to turn over any evidence that identifies the defendant or suggests that the defendant committed the crime, right? Because we have self-incrimination issues that come into play. So it's very one-sided, but it's done to be as protective as possible. Now, I will say this, your book incorrectly notes that extrajudicial evidence is not admissible for any court proceeding. This is not true. So we can use extrajudicial evidence at really any stage of the criminal case, except for the part where the jury trial or the bench trial, the part where guilt or innocence is being determined. Anything before that and anything after that, we can use extrajudicial evidence. Now, so the example I give you is polygraphs. So in 49 states, polygraphs are not admissible in court. One state is, I think it's Oklahoma. The feds don't allow polygraphs in court at trial either. Polygraphs are very unreliable, very subject to human interpretation. People respond to things in different ways. There are ways to beat polygraphs. A lot of people fail polygraphs who are actually innocent. There's a lot of problems with polygraphs. Yet, if you want to go into law enforcement, you're going to have to take a polygraph test. It's always kind of stood out to me. It's like, so you know this doesn't work, but you're going to require people to do it. That makes a lot of sense. But polygraphs generally not admissible, right, at trial. But they are admissible at suppression hearings or bail hearings. So, for instance, you're doing a bail hearing where you're trying to get bail for your client who's charged with murder. And there's not a lot of evidence. And you're arguing to the judge, there's not a high likely that this person will be convicted. They don't have that much, there's not really that much evidence. You're not going to bring up the polygraph that you confessed in, right? Or that your client confessed in, if you're the defense attorney. But you can bet that prosecutor can say, no, actually, there's a very high likelihood of conviction. While it's not admissible at trial, Your Honor, we do have a polygraph which shows that the defendant was deceptive during key questions about the investigation that do point to his guilt. Now, we're going to try to have a lot more information than that. But if that's all we have, then that's the hearing that we have. So the prosecution rightfully discussed polygraphs, right? That you cannot use them at trial. You can't let a jury hear them or a judge determining guilt or innocence hear them. But you can use them at really any stage before the trial, right? So you can use them at suppression hearings, you can use them at bail hearings, show cause hearings. I mean, you can use extrajudicial evidence at any point except the trial. So I just want to point out that discrepancy in your book and make sure that we know that extrajudicial evidence, not at trial or for most proceedings, but it still can be brought in for other proceedings. So the presence of evidence alone doesn't mean that investigators can prove the two goals of criminal investigation, right? So just because we have evidence doesn't mean we can necessarily prove that a crime occurred and that the defendant is the perpetrator of the crime. Instead, when we think of proof, because proof is kind of like this absolute yes or no, we can never get there, ever get to a solid yes or no, right? Instead, proof exists in a continuum of certainty, right? So on the left-hand side, we have 0% certain. And on the right-hand side, we have 100% certain. We, as human beings, can never, ever get to 100% certain of anything. Now, I know what you're thinking. You're thinking, what? No, there are something, like, you just know. Like, for instance, this pen, right? I know it's a pen. I think I do, at least. It's got a cap. It's got a body to it. Am I right? It's black ink, right? And that's what I've been told and taught a pen is. I know this is a pen. But do I? Is it possible? Is it possible? Not likely, but is it possible that this actually is not a pen? That what this is a butterfly. But aliens have trained my brain to believe that butterflies look like pens, write like pens. Is that possible? Weird-ass alien theory. Yes, it is possible. I mean, we don't understand everything about the universe, or even close. So yes, it is absolutely possible that this pen is actually a butterfly. So we never are 100% certain of anything. Right? It's kind of like the Matrix. You can't be certain about your reality. Now, when we talk about criminal trials, what we tell juries is they have to find proof, or they have to believe that the defendant committed the crime, and the prosecution has to prove it beyond a reasonable doubt. right? So I'm not 100% certain that this pen is a pen. That could be a butterfly. But that's not the standard we ask juries to use. Otherwise, everybody would be found not guilty. Juries use beyond a reasonable doubt, which is about 95% certain, right? So am I 95% certain that this is a pen? Because is it reasonable to believe that aliens have tricked my mind into thinking that a butterfly is a pen? It's a possibility, so that we're never going to be 100% certain, but is it reasonable based upon what we know? No, right? I mean, this based upon touch, look, sight, what it does, it's a pen. I'm 95% certain. 100% certain? No, but I'm 95% certain. And that's what we want to see, right? But if we hold this up and say this is a pen, it's air pods. But we hold this up and we say this is a pen. Then we say, okay, well, I know pens write things. I know what a pen looks like. That doesn't look like a pen. And does it write? It doesn't write. And there's things that come out of it that doesn't seem like a pen. Well, you have reasons, right? So if you have a reason, if you have an articulable, in good faith reason that you don't believe that something occurred, right? That the defendant didn't do that this is not a pen, then you have to find the defendant not guilty in a criminal proceeding, right? So we have to prove just to that 95% mark. And again, that's really just based upon, are you able to articulate reasons why you don't believe that this is a pen or that this is AirPods? Like, do you have reasons that you're able to articulate? That's kind of what we're looking for reasonable doubt. If you have reasons that you can articulate that are reasonable, that a normal person would find reasonable, then yeah, you have to find not guilty. But if everything besides weird hypotheticals that seem like they could never happen, but if you prove it beyond that, then yeah, you can find the defendant guilty, and you're supposed to. Now, what we will see is that on this continuum, there will be some phrases that come up, some terms that are very key. So beyond a reasonable doubt is our ultimate goal in terms of trying to, if the prosecution is trying to convict someone, that's what the prosecution is doing, they want beyond a reasonable doubt. They want enough evidence for beyond a reasonable doubt. But there is enough evidence lower than that for different things. So at 50.01%, we have probable cause. Right? This is also the same standard for preponderance of the evidence as which we use in civil trials. But probable cause is what we usually need to get a warrant or to conduct some kind of search and seizure. Right? Probable cause just means it's more likely than not that a crime was committed and that this person committed the crime, or that we'll find evidence here of a crime that's been committed. I mean, whatever you're arguing to get your warrant, all you have to show is by 50.01% or 51% or 50% in a feather. It's been defined a bunch of different ways, right? And then kind of down towards the bottom end of the spectrum, we have reasonable suspicion. This allows us to stop people and just real quickly ask them some questions if they're acting suspicious to dispel our suspicions, right? Here, we only have to be 25% certain that something's going on. Right? That's not a lot. That's just kind of like, that seems a little weird. That's it. That's all you need. Then you can make the stop. You can stop a car, you can stop a person, whatever, and kind of just ask them questions. They're not free to leave at that point. Ask them questions until you can understand why they're there, or until you develop probable cause, and then you can make an arrest, or you can get search a vehicle or something along those lines. Right? So reasonable suspicion, a very low threshold, nearing the zero end of the scale. So just kind of understand that this is a continuum. And yes, in an ideal world, you would find enough information to get a beyond reasonable doubt conviction every time. We're going to see that's not really the case. because police are often concerned with probable cause, because probable cause is what you need to get an arrest warrant. Right, so if police are like, okay, I've got enough evidence to show it's more likely than not that the defendant committed the crime, or the crime was committed and the defendant committed it, they can get an arrest warrant. They can make an arrest. They can set that person up for trial. But if all they have is 50.01% certainty in evidence, that's not beyond a reasonable doubt. It's not even close. Right, so prosecutors think they need evidence beyond a reasonable doubt. That's what they're looking for from police. Sometimes police think that once they find probable cause, once they make an arrest, the investigation is over. In reality, it's not, because they have to find evidence beyond a reasonable doubt. And again, any evidence that they find, whether it's admissible or not admissible, may be found or considered Brady material and subject to being turned over to the defense. So again, when we're thinking about probable cause, basically we're looking and saying when the facts and the circumstances would lead a reasonable person to believe a crime has been or is being committed, right? So a reasonable person can believe that a crime is being committed even when innocent activity may just make them feel suspicious, right? To establish probable cause, or at least a reasonable suspicion. So one example is there is a car, right? It's this beat up, torn up car, old car, barely running. It's got like plastic instead of windows. And it's driving through this neighborhood. And it kind of makes a few trips around the neighborhood slowly. And the neighborhood happens to be occupied by multimillionaires, right? So this is where all their mansions are. And he's driving slowly in front of each mansion in his beat up car. That makes me suspicious, right? I mean, that's suspicious, right? Like you obviously don't belong here. And why are you slowing down to look at each mansion? And you've gone through a couple times. Now, the reality is that person could literally just be driving through the rich part of town just so they have a goal, or they just want to see the houses and see like how giant they are, and it's just really impressed with them. That's completely innocent activity, and it's completely legal. You can drive through neighborhoods, you can go slowly, and you can even park in front of houses and look. Like, I mean, it's completely lawful. Creepy, but lawful. So it's innocent. But a reasonable person would be like, that doesn't seem right. Third time I've seen this car, and they slow down every time they get in front of this mansion. The car obviously is not a Ferrari, it's not a Corvette. It doesn't meet what this neighborhood can afford and what this neighborhood anybody drives, right? So again, that's the right circumstances for probable cause, or at least reasonable suspicion. I'm going to stop that vehicle and I'm going to ask them what they're doing, right, if I'm a police officer. Now, there is a caveat, right, to this probable cause determination. So if evidence is acquired through an informant, courts under the case Gates look to a totality of the circumstances as to see if what the informant said is true and is enough to rise to the level of probable cause, right? Because often we have informants who kind of get quid pro quo, right? Like, so they get popped for a very low level crime, but they have information about a very serious crime. Well, if I'm the prosecutor, I'm probably more concerned about the serious crime than I am shoplifting. So I might make a deal and say, you know what, you tell me what happened, and if we get a conviction, I'll drop the charges. That person's an informant. That person now has an incentive to get somebody found guilty of a crime, right? So they get off of their own crime. Sometimes we let informants live that are reliable, just live their lives, right? So if we have an informant, and the informant is actively engaged in the drug trade, right? But they're giving police and they're telling police what's happening and different things like that, or what's happening on the street, what the word on the street is. We're not arresting them as long as they're giving us information. But that implies an informant actually has information, right? So we used to just look at the Aguilar-Spinelli test, right? And basically what we said is, all right, how reliable is the informant? Right? So have they given us evidence before and it's been true? And the source and the reliability of the information. So like, where did this information come from? Did the informant see this, or did the informant just hear about it? How reliable is this? Today, under Gates, we look at the totality of the circumstances. So we don't just look at these two factors. We look at everything in the universe that we know, right? And we say, based upon, because the informant's information, that's evidence. We look and say, based upon totality of circumstances, everything we know in the universe, is this reliable information that could be used to meet the probable cause threshold? We can use corroborating evidence and things like that to show, like, yeah, he's telling the truth. Here's evidence that shows this, right? There we have to worry again about confirmation bias and things like that, and kind of what our role is. But to that end, this is kind of where we're at in terms of how we look at informant evidence. When we think of evidence, again, we look at the forensic classifications, right? So is it judicial evidence or is it extrajudicial evidence? All evidence is also classified as either direct evidence or indirect evidence, right? So direct evidence immediately demonstrates the evidence of a fact in question without the need for inferences or presumptions. Okay? So what does this mean? This means we have a confession, right? Person says, walks to the police station and says, I just killed my wife. And we find out, yeah, they killed their wife. That tells us right away that they killed their wife, right? But there's no need to infer anything or presume anything. They just told us. Right? Same thing is true for eyewitness identifications, right? If you saw the murder and you say the murderer was Bill because you saw Bill do it, or you were scared that he was going to kill you, but he didn't see you, or whatever the story is, right? That's not eyewitness identification. And they go into court and they say, do you see the man who you saw stab the person here? Yes. Let the record reflect that the witness has identified the defendant as the person of interest, or however you want to word it. So to that end, those are really kind of the only two times when we don't need information or make inferences. That's direct evidence. Direct evidence is very, very rare. It's also, especially if we're talking about confessions and especially eyewitness identifications, also the most likely to not be reliable, right? So direct evidence is no inference, but also the least likely to be reliable. Instead, where we fit most evidence is into direct, or otherwise known as circumstantial evidence. So this is crime-related information in which inferences and probabilities are needed to draw an associated conclusion, right? So this is, we find a fingerprint, right? Now, the fingerprint has several things, and we're going to talk about fingerprints, but generally speaking, depending on the humidity, they don't last more than 24 hours. If you're in Alaska, a fingerprint on a surface is going to last a lot longer than it is on a surface, same surface in Arizona, all this other stuff. But what we do is we find a fingerprint. Does that fingerprint immediately demonstrate there was a crime and who did it? No. right? We can infer that, yeah, this is Bill's thumbprint. We can infer that he was there, but we're gonna look at fingerprints, and it turns out that you have a unique set of fingerprints. It's actually it's a myth. Right? There's like 7.5 billion people on the planet. We don't have unique fingerprints. The ordering of the fingerprints is what makes it unique and statistically within the ballpark. But even with like DNA, if we find DNA evidence, DNA is not immediately demonstrative of the person committed the crime or a crime was committed. It might just be that the person was there. People can go places all the time and not kill people, right? So maybe we're in Alaska, and yeah, last week you went and visited your grandma. Now you're arrested for grandma's murder because they found your fingerprint. Well, the fingerprint infers and kind of assumes that you were there during the commission of the crime, right? And how do we infer that? We use probabilities. We say that, fingerprints are basically 80% water or 20% oil. They're chance impressions, so we don't leave a fingerprint every time we touch a surface. And based upon that, it's unlikely that this fingerprint was from 2 weeks ago, but since we found it was occurred within the last 24, 48 hours, something along those lines, right? So we have to draw a conclusion from it. It doesn't tell us right away if the person's guilty or not, because there are perfectly good reasons to have your fingerprints in different people's houses. Like, they're your friends, you visit them. Like, that happens, right? So we have to make an inference based upon probability that, well, this actually is important in this case because it shows that X, Y, and Z. So that being said, you always hear on TV shows like Law and Order or something along those lines that we can't do this. This case is entirely circumstantial. Like, judges say that. As it turns out, most cases are circumstantial. Very rarely do we have a confession or an eyewitness. Right? If we do, there can be problems with them, right? They're kind of the least likely confessions and eyewitness identifications to be accurate. But even knowing that, confessions and eyewitness identifications rarely occur, right? Eyewitness identifications, usually again, this is information theory, but if you're going to perpetrate a crime, you're probably going to make sure that nobody sees you do it because you don't want to go to jail, right? So you're probably not going to have eyewitness identifications. And if you did something serious enough, you're probably not going to confess. Now, you watch like the first 48 and they always confess every time and things like that, and that's not true, right? The more likely it is that you are to confess kind of decreases with the seriousness of the crime, right? Like, if I get popped for littering and the judge is like, "Did you litter?" I'd be like, "Yeah, I did." If I get popped for murder and the judge is like, "Did you murder this person?" I'd be like, "Nope, not me." Because the consequences are so drastically different, right? And again, most cases are circumstantial, and circumstantial evidence, if it's put together in a way that proves somebody is guilty by at least 95% certainty, then you have a conviction, and the conviction can stand entirely on circumstantial evidence. Right? If we needed a confession or an eyewitness identification in every case, most cases would go unsolved, right? Completely unsolved. So we usually rely on indirect circumstantial evidence. The distinction is kind of based on what's being proved, right? So consider our fingerprint example, or fingerprint on a knife. Right? So are we trying to prove that the defendant touched the knife? Well, if that's what we're trying to prove, then the fingerprint on the knife is indirect evidence, but it's evidence of a crime, or evidence of, probably, for which I prove it, evidence of a crime. That it's important to know that the defendant touched this knife. But if we're just trying to prove that the defendant had been there, And that's why, like had been there and like helped cook dinner or something like that. And that's why there's fingerprints on the knife. Really, we're looking at the probabilities, right? And the rest of the evidence, the rest of the puzzle pieces, as much as I hate to use that term, the rest of the puzzle pieces, we put them together to show that we have fingerprints on a knife. It's not just proving somebody was there, it's proving somebody was touched it or somebody used it or whatever we're trying to prove, right? We have to use other evidence to supplant and to shore up our circumstantial evidence. So we just have circumstantial evidence that's shoring up other circumstantial evidence, and we just kind of build this tower of circumstantial evidence until we get to beyond a reasonable doubt. Now, somebody can pull something out of the middle of the tower and it fall like Jenga. I mean, there's always things that can come up. But really, indirect evidence is going to be really, 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 really important when we're thinking about how we prove a case and what we need to look for when we start looking at bodies and we start looking at wounds and we start looking at things along those lines. So that being said, when we talk about the types of evidence, so in addition to being forensic evidence typology, in addition to being direct or indirect, all evidence can further be classified as follows: testimonial evidence, real evidence, demonstrative evidence, documentary evidence. Right? So we classify things and subclassify and sub-subclassify. So you might have something that's judicial, but it's indirect, and it's actually testimonial. Right? Usually testimonial can be direct, but you kind of break it down in that way. So when we talk about this typology and these types of evidence, testimonial evidence is oral testimony under oath in court. Right? Now, when we think about testimonial evidence, again, you watch Law and Order, they always confess on the stand, and it's this big to do. No, that doesn't happen. Like if you're a defense attorney, you don't let your client take the stand ever. Unless you, like the once in a lifetime case. That being said, there is something to understand and consider, and this kind of actually works in a couple of ways. There's a difference between an admission and a confession, right? A confession is, yes, I was there and I committed the crime. Right? I committed the crime. There's your confession. As opposed to, yes, I was there. That's an admission. You admit that some of part of this evidence is reliable, real, right? You're saying it in court that, yes, I was there. Did you do it? No. Then we don't have a confession. We have an admission, right? So we can admit things in evidence, but just because somebody admits they were somewhere at some place at some time doesn't mean they committed the crime. All right, so an admission and a confession are different. And again, admitting confessions, you're always going to have a challenge to exclude the confession. Like even if it was completely fine, you're always going to have a challenge. We talked a little bit about hearsay. Hearsay is this idea of you come into court and tell me what you heard some other person say. Generally, we don't allow it, but there are, to say several, there are numerous exceptions to hearsay, which can allow hearsay to come into play. Right? And again, those are articulated in the rules of evidence as well as case law. We also, under testimonial evidence, have expert testimony. Right? So I have two things on here. I have Fry and Dahlberg. Expert testimony is somebody who doesn't have knowledge of the case, right? Or didn't have knowledge of the case, wasn't there, didn't find some piece of evidence, or they're not, whatever. Experts get called into play when there's something scientific or there's something that requires specialized knowledge that needs to be conveyed to the jury that the jury just doesn't have. right? Let's say the case involves, I don't know, nuclear fission, and I need to know the intricacies of nuclear fission to understand what and to interpret the evidence correctly. I don't care if we go 10 years, I am not going to understand what nuclear fission is. Right? Just I'm like, if I do my own research. But if we have an expert come in, the expert is there to explain to the jury what the scientific evidence is and what it means. And most experts get paid a lot of money because they're also experts at talking to juries. Right? So all too often, I would see my colleagues or on the opposing side, prosecutor would have somebody get up during trial and they call an expert witness, right? Because they found a fingerprint. The expert needs to come testify about the fingerprint, where it came from, like how you did the analysis, how certain you are that this fingerprint belongs to the defendant, whatever, and the science behind it, right? All too often, my brothers and sisters on the other side would get some crime lab tech to come talk about what all the evidence meant. And the techs or the crime lab people were scientists. I mean, they are scientists, literally. If you want to be in criminalistics, if you want to be CSI, you should be taking criminal justice classes, but you should also be taking chemistry or biology or hard science. Because not only is it enough to collect it, but you also have to explain it, right? So let's say you call the fingerprint expert to the stand. We have, since they weren't there, they don't have actual knowledge of what happened. They can just testify about the fingerprint and what they learned was studying the fingerprint, things like that. They can't testify as to guilt or innocence. They can only testify as to inclusion or exclusion. So let's say you have this tech who has no idea about the crime, whatever, and they used, and this is my colleagues always would do, is they would hire someone, they call someone in to explain the evidence, and they were true scientists, but they didn't talk to the jury, right? They were just saying, well, I used a M95X -Q ridge analysis analyzer with 15.6 cubic beats of RAM, and they just kind of just went on. You're like, that, what? I don't understand what the hell you're talking about. The reason they're doing it is because what experts use and how experts work, like when they're testing evidence, we have two different standards to allow that to go to a jury, for a jury to hear how some scientists tested evidence and what it meant and all that jazz, right? So we have, for the longest time, the general acceptance test, right? And the judge is supposed to ask, is the science that's being discussed, is it generally accepted in the scientific community, right? Now you can see this as a problem because it limits new exploration and apply it to new things. So for instance, DNA didn't become a thing like that we thought of we could use in criminal investigations or anything like that until the 1990s. If we relied just on a general acceptance test, half the time that we tried to prove that somebody was guilty, they wouldn't be able, or that the expert came to testify about DNA, most of the time they wouldn't be allowed to, right? Because when DNA is new and people in the community haven't scientifically accepted it, it's not. Kind of like everyone says, like, climate change is real. That kind of standard, right? Then we got Dahlberg versus Merrill Pharmaceuticals. It's called the Dahlberg Gatekeeper test. This is what most states use, right? The Gatekeeper test basically says, all right, the judge is the ultimate makes the ultimate determination as far as evidence is concerned, and is concerned primarily with making sure that a court proceeding is fair, right? So what we're going to allow them to do is we're going to allow them to make a decision. Yes, they need to take into consideration, like, does the general scientific community accept this? But they also need to take in a bunch of other things. They're going to have to base their decision on the totality of the circumstances and the totality of the information. But they look to, yeah, is it accepted in the community? Well, what if it's new? Okay, is there a known error rate? Like, how often does it produce a false positive or a false negative? Right? Has it been subject to peer review? So have you published this information and let other people try it and experiment with it to see if what you're saying, they find the same results? There's all kinds of information that we try to get, and judges can ask the questions of expert witnesses. Expert witnesses can be voir dired, so that means asked questions relating to their scientific discipline to see if they're truly should be admissible. So being an expert witness, being a CSI, you really have, I mean, to be effective, you definitely need criminal justice majors so you understand the process. Take communications classes as well so you understand how to talk to people, as well as your science classes. And be prepared to take nuclear fission and explain it to somebody like me who has the IQ of a cow. Like, you have to really break that stuff down. So that's testimonial evidence, again, oral testimony under oath in court. Then we have what's called real evidence. And now this seems misleading because everything is real evidence if it's evidence. But what we mean by real evidence is what we think of when we really think of, like, evidence, right? We're thinking about tangible objects, so that can be seen or held, and that produced as a direct result of the crime, right? So real evidence would be the murder weapon. So we get to a crime scene, we find a body, and then in the room over, we find a gun lying on the floor, smoking, and the body had been shot. The gun is still smoking, still hot. Even if it's not, like, the fact we found a gun at the scene means we're going to take that gun in. That's real evidence. I can touch the gun. I can't touch your testimony. I can't touch people's testimony. I can touch the gun. I can hold it in my hand, right? And as long as it relates to the crime or is a direct result of the crime, then it's considered real evidence, right? So this could be this could be contraband. So this could be drugs. This literally anything that you can hold. Anything, literally, again, even iPod case, like, anything that you can hold is real evidence. With an exception, sort of, right? Brings us to our third type of evidence, which is demonstrative evidence. So these are diagrams, right? You can hold up a paper with a diagram on it. Videos, really anything. Produced to aid the jury, to assist them in understanding the evidence, but it has no evidentiary value, right? So one common thing to do when it comes to demonstrative evidence to show a jury is to show, if you're trying to prove that this guy committed 12 burglaries, right? It's one thing to hear somebody say, oh yeah, well, he was on West 7th Street, then he was on, there was a burglary at 47 Miller, which is like 4 streets over, and you kind of have to go down this alley. And that can get confusing. That's one thing. Like, and juries need help. Like, there's 12 burglaries. I'm not a cartographer. I don't know where stuff is, right? I mean, I've lived here 5.5 years. I know how to get to my office and my house, and that's about it. So if you start telling me street names, I'm not going to have a clue what the hell you're talking about. So what often happens is the prosecutors will blow up a map, like a Google Maps, right, or Google Earth. They'll blow it up, and then they'll have the person put stickers on the demonstrative as to everywhere that a crime that they accused him of, the defendant of, occurred. Right? Now, demonstrative evidence, it doesn't have any evidentiary value. Right? It's not supposed to be like, oh, the juries don't rely on it. It has no evidentiary value. It's just there to help clarify the evidence, whether it's testimonial, real, documentary. It's there to clarify and help us understand. Right? So if I blow up a map from Google Earth, and I make it really big, like I make this big picture of it, that in and of itself isn't evidence, and it's not telling us, it's not being prejudiced one way or another, right? Because we're just showing what this person said. This person said that these are the streets this occurred on, and we're saying, okay, let's look at this visually, right? So one demonstrative that we used in mock trial is this, right? So this was from last year's case. Hopefully you can see it. It can come in, demonstratives can come in as an exhibit. So they can come in for juries to review. But this has no conviction value whatsoever, right? All this is a map of basically trails at a campground. Like where the trails are, where they go. That's it. That doesn't tell us anything in terms of whether the person committed the crime or not, right? It's just there to help us understand, like, oh, so you're at this part of the trail, right? And then there's documentary evidence. So this is documentation relating to the crime. So surveillance videos are documentary, right? Because you can't really hold the pictures that they're showing. You can hold the videotape, but you can't hold the pictures. Forensic reports, again, we're trying to get the information from them, and things along those lines. So those are documentary evidence. So again, if you're asked to classify evidence, you ask first, is it forensic or non, or is it forensic? Is it judicial or non-judicial? Is it direct or is it indirect? Is it testimonial, real, demonstrative, or documentary? Right? And that's how you kind of classify evidence and sub-evidence. And then you'll see if you're testimonial, you kind of have to ask it a little bit further. Is it a lay witness? Is it an expert witness? So on and so forth. So in addition to classification, evidence can function several ways. So it can be corpus delicti, or delicti, evidence, which establishes a crime occurred. Or it can be corroborative evidence, which basically supplements and evidence that we already have, right? So it's something comes into evidence, and then I offer something that shows, yeah, that's what that thing that I said is true. Like that this helps that, right? It helps confirm what that piece of evidence said. So this is, Bill saw Jill at the party. Carl testifies that he saw Jill at the party. Well, Bill's already testified to that, but Carl adding to that is corroborative. It's not new evidence because this person said they saw Jill. So this is not new, but it helps, and it shows, if we do it enough times, like that Jill was at the party, right? Enough people have said it. Now, we can't be too cumulative, and that's something we have to look out for, is cumulative evidence. Cumulative evidence duplicates, so it says the same thing, but doesn't necessarily strengthen the evidence. And it's often a violation of the Federal Rules of Evidence, the FRE. So when we think of cumulative evidence, it's corroborative evidence that just goes too far, right? So let's say we have a party of 500 people, and I have 400 people who say they definitely saw Jill. The others didn't, but 4 out of 500 saw Jill. If I try to call 400 witnesses just to say that Jill was at the party, it's just not going to happen. The judge is not going to allow that. Even though it's corroborative, at some point, evidence goes from being corroborative to cumulative, right? So yeah, could I stop at 100 and we all just say that Jill's at the party? Can I stop at 50? Like, well, I don't need 400. I don't need 100. Can I stop at 20? How about 3? How about 4? 3 to 4 is pushing it, right? If you have a couple people that say this is what they saw and they say the same thing, that's corroborative, it's not cumulative. But if it doesn't help move the football, if it doesn't help us, like if we're like, okay, yeah, 400 people later, yes, Jill's at the damn party. And then you're like, I'm going to call 401 and tell, so he can tell you he saw Jill at the party. He's just like, no, it's not helping your case. It's not helping move the football one way or another. It's just cumulative. Then we have associative evidence. This is evidence that can establish a link between crimes, crime scenes, victims, suspects, or instrumentalities. So instrumentality is something that somebody used to commit a crime. Usually the instrumentality of a crime is going to be something like a gun or a knife or a bat or whatever it is. And again, this is evidence that establishes a link between, so let's say there's a gun left at the crime scene, right? That is not illegal in itself or anything along those lines, or even if it is, that's not what we're investigating a murder. So we find a gun in a crime scene. That gun, if we believe is what used to kill the victim, that's the instrumentality that was used, right? It's associative evidence. We're saying that this gun was used to commit this crime, and based upon the serial number, this gun belonged to Bill, right? So we can kind of say that there's a link between Bill and the smoking gun found at the crime scene. It was his, right? And then we have to go further and prove that the gun is actually what killed the victim, right? And so we kind of build a case that way. Now there's identification evidence, evidence that leads to the identification of the perpetrator. So again, this is going to be usually direct evidence, usually eyewitnesses. And then we're also going to have behavioral evidence, which provides a basis on which to identify who may be responsible for a particular crime based upon a series of factors and stats. So when we think of like criminal profiling, this is kind of what we think of, right? And if you ever watch Criminal Minds, they always say, oh, man, it's probably in his 30s, white male, recently went through some kind of trauma or whatever. They get really specific, which that doesn't happen in real life. What they're doing is they're just using stats and factors. So they look and say, okay, this crime is a lot like the other 900 crimes that I've investigated over the years. And in those 900 crimes, out of 899 of them, only one was perpetrated by a female. So I can pretty confidently say you're probably looking for a male in this crime, right? Based upon the fact that this crime is like all the ones I've investigated before. So they use statistics, and if you want to get into that line of work, you definitely have to go to graduate school. You definitely need to have a very good command of statistics, because that's really what it takes. You're just making an educated guess as to behaviors or as to somebody's identity, who's related to a crime, just based on what you see the crime scene and what those factors tell you statistically. So that being said, it looks like we are running out of time. We don't really have too much time to work on the case file of Stanley von Wagner. We will start here at the next video, but I did want to talk a little bit about the actually, you know what, we'll save it. We'll start next class. We'll talk about the Stanley van Wagner case and look at the evidence. And I encourage you to reread it now that you kind of understand like what the sub-classifications of evidence are and what the purposes are. Remember, there's differences. There's judicial, extrajudicial, direct, indirect, etc. Versus what the purpose is. Is it associative? Is it identificative? Well, what is it? So take a look at the Stanley Wagner file, see what the cumulative evidence, see if there's cumulative evidence, see what the circumstantial evidence is. If there's circumstantial, see what direct evidence there is, if it's direct, and then we can talk about it and say, how would you approach this if you were investigating this crime? What could they have done better? What could they have done differently? What did they do well? What did they not do well? What's the defense attorney going to do? We'll kind of get a little bit more into that. So we'll start that at the next class, and then we'll focus and pivot on physical evidence Right, so this is usually real evidence, and the crime scene. Right, so we're going to start talking about evidence and its relationship to the crime scenes and how those work together. That being said, thank you for watching. And if you have questions, please always feel free to email me. And I will get back to you, or make an appointment, or text me, or however you want to get a hold of me. And I'll be happy to answer your questions. So that being said, thank you for stopping by, and I'll see you next class.